Chief Justice, and may it please the Court, my name is Pat Farshone and I represent the appellee, Jeremy London. There are two issues before this Court today. The first issue is whether the Ohio Court of Appeals correctly concluded that Zuber is a public figure pursuant to New York Times v. Sullivan, requiring a showing of actual malice to recover on defamation. The second issue is whether the First Amendment protects statements which suggest that products are unsafe for human consumption when those statements were made based on information obtained from a source who was believed to be reliable. I will address these issues in order. Zuber's extensive advertising practices require that it be categorized as either a public figure or a limited purpose public figure, both requiring a showing of actual malice to recover on defamation. Ohio's actual malice standard requires proving that the statements were made with knowledge of or with reckless disregard to their potential falsity. Several jurisdictions have held that statements made in reliance on an unverified source do not meet the bar for actual malice, so London's reliance on Jacoby does not constitute actual malice. Alternatively, if Zuber is classified as a private figure, it cannot prove actual harm, as a barley shortage occurred around the same time that London made his statements. This barley shortage led Zuber to raise the price of its beers across the board, which resulted in the dip in sales. In summary, Zuber cannot show actual malice or actual harm, so it cannot recover on defamation. On the second issue, this Court should uphold the Court of Appeals' ruling of summary judgment for London on food disparagement. The relevant statute is Ohio Revised Code section 2307.81, which allows recovery for false statements made about perishable agricultural products where the statements lacked reasonable and reliable scientific backing, and the disseminator either knew or should have known that the statements were false. London produced sufficient expert testimony to show that his statements have reasonable and reliable scientific support. According to the seminal food disparagement case, Texas Beef Group v. Winfrey, the knew or should have known standard in food disparagement is the highest available in law akin to actual malice. London's source of information was an ex-employee of the company who misled London with doctored documents, so it is not reasonable to say that London either knew or should have known about any potential falsity of the information. Beer is not a perishable product that is meant to be protected by this statute. A perishable product must decay beyond marketability within a reasonable period of time. Beer's shelf life is much longer than actual perishable products such as meat or veggies, so it does not fit the definition of perishable. Alternatively, beer is not agricultural. Beer's ingredients must be processed to a significant degree to make the final product, so it should be considered an industrial product instead of an agricultural one. For the reasons stated above, appellee respectfully asks this Court to uphold the Court of Appeals ruling that appellant is a public figure who must prove actual malice to recover on a defamation claim. And for the reasons stated above, appellee respectfully asks this Court to uphold the Court of Appeals' grant of summary judgment, holding that appellant cannot satisfy the statutory fault clause requisite for recovery. Thank you.